Good afternoon and welcome to our webinar. This is Why You Might Need a Trust, and I'm Kate Godber, a solicitor at EHL Solicitors. First of all, my aims for today and what I hope that you'll get out of the webinar. A lot of people think that trusts are complicated and unknown, and therefore they possibly shy away from these. What I'd like to do today is show that trusts are not as intimidating as you may think. My aim is to break down the barriers to enable you to understand why trusts may be needed and to understand some of the reasons for doing trusts. What I have done then, and I aim to do, is to give you 3 examples of situations where trusts may be needed, and hopefully you will then be able to recognise situations when you or any acquaintances you may have may need a trust. So the first example that I'd like to go through with you are trusts for properties. People often want to put properties into trust, and they may do this for a number of reasons. They may do it for tax reasons, protection reasons, or simply to illustrate who may receive money from a property in terms of rental income or capital. So, examples of trusts for properties. The first one would be a simple declaration of trust. People quite often use a declaration of trust to explain who owns a property beneficially. So by that I mean that legally somebody would own the property, but actually they may well be holding it on trust for somebody else. An example of this would be if someone legally owns a property, but they were actually lent some money by a family member to buy the property in the first place. And in return, they may either expect to receive that sum back when the property is sold, or receive a percentage of the equity, so the profit that's been made on that property when it's sold. A declaration of trust is a fairly straightforward document and is simply used to evidence this relationship. Declaration of trust can also be used if a property is owned jointly. You may hear people talking about owning property as joint tenants or tenants in common. If clients own property as tenants in common, they may not actually own the property equally. So it may be that they are expecting one party to receive 25% out when the property is sold and one is expecting 75%. And a declaration of trust can explain what proportions the property is owned in. Again, this can be a simple declaration of trust, or it could be slightly more complicated. It could explain who is responsible for paying the mortgage, or who is also responsible for paying for repairs or maintenance of the property. So that can be a straightforward document or a bespoke document for your clients. If a property is rented out, that will obviously have an impact on the income that is received by each party. So again, if you've got that 25-75% split, 25% of the income may pass to one party and 75% may pass to the other. Again, also the equity being split would be evidenced by what's in the declaration of trust. A good example of this is where husband and wife may want to change the way the property is owned because they want the income to be taxed in one party's hands and not the other. So for example, if husband or wife is a lower taxpayer, it may be that they want to make sure that the income is paid to the lower taxpayer so that less income tax is paid. As gifts between spouses are not taxable for inheritance tax or capital gains tax, a declaration of trust is a useful tool to make sure that the spouse that pays the lower rate of income tax and capital gains tax is given a higher proportion of the property. That's declarations of trust. The next trust that you may have heard of and may be coming across more and more are asset protection trusts. This kind of trust basically transfers a property from somebody's name into a trust, and usually provides that a certain party is able to live in that property during their lifetime, and then on their death, the trust would explain where the property will pass. The features of an asset protection trust are that it it is still treated as the donor's assets for inheritance tax purposes. So this is quite an important point, because a lot of people think that if they put their own property into an asset protection trust, but they continue to live there, that it will no longer be treated as one of their assets for inheritance tax purposes. That isn't correct. It would still be treated as their asset for inheritance tax purposes, because they will continue to receive a benefit from it, i.e. they will still be able to live in that property without paying any rent. The asset protection trust, though, does allow the person giving the property away to determine who will receive this asset on their death. An example of an asset protection trust that I've done recently, this was for a husband and wife who lived with their adult daughter and grandchildren. The daughter and grandchildren have no legal interest in the property at all, so this was owned by the husband and wife. But inevitably in that situation, the parents wanted to make sure that she would be able to continue to live there following their deaths, and that the property didn't pass into their estate and therefore didn't pass to their other children, leaving this grown-up daughter that lived with them homeless. It's a good example of when an asset protection trust is needed in this situation to protect the daughter's interest. Another example then of when a trust is needed is in a will. This may be needed for a number of reasons. You may come across trusts and wills because they want to protect assets for future generations. So, for example, people maybe don't want to give the assets outright to their children. They want to leave it in a trust to ensure that their children could perhaps benefit from it, but that maybe, in fact, they want to give the money to the grandchildren eventually. They may, of course, feel that the grandchildren potentially would be too young at the death to receive this money outright, and therefore a will trust would be a useful way of protecting this money until they were older. The other reason that you might use one would be to protect from divorce or bankruptcy of beneficiaries. If someone's left money in a will and then they go bankrupt or are divorced, obviously the money that they got in their names would be treated as their assets for both of those purposes. And that may not be what the person doing the will intended, and they may have preferred actually to put it in a trust to effectively safeguard it from those situations, to make sure that people don't get their hands on it who maybe they hadn't intended to. Another reason that you might use a trust would be to enable a spouse or partner to benefit from assets that are held in the trust during their lifetime. So effectively, there's money sitting in a trust that the spouse can benefit from, but that if they don't use it, it doesn't become part of their assets for inheritance tax, simply sits in the trust and ultimately passes on to the next generation, being either their children or their grandchildren. So an example of when a trust is put in a will is often in the case of a second marriage, where although assets are viewed as equally split between the married couple, they each want to ensure that any children from a previous marriage are provided for on their death. In this situation, I would recommend something that's called an interest in possession trust or a discretionary trust, and that would allow the spouse to benefit from any assets held in the trust whilst they're alive, which is exactly the situation I just described, but that on their death, their assets would pass to their children. This avoids everything passing to the spouse on the first death, and then potentially them changing their will to leave all assets to their chosen beneficiaries. I have seen this done before, where the clients would say, "Oh, but I do trust my spouse," and actually they leave everything to them, and they say, "Well, they know that I want them to receive to give a certain amount of money to the children," and of course, once the money is actually in that person's assets, they can do whatever they want to with it, and they could spend it, or they could change their own will to leave it to somebody else. Trusts and wills also exist where money is left to children under the age of 18, this is the simplest form of trust, and in this situation it would be up to the trustees appointed in the will to invest the money until the children attained the age specified in the will. That's not, although that is a trust in a will, that's not strictly what I was really talking about in this section. I was really talking about the kind of discretionary trust or slightly more complicated trust where trustees are having to make decisions about where assets are paid to. In that kind of simple trust that I just described where money is left to children under a certain age, that really is simply where money is sat, invested until that child reaches a certain age, and then the money is paid to them. The third example then that I wanted to give of trusts that many of you may come across on a regular basis is trusts for life insurance and pension policies. Putting life insurance and pensions into trusts before someone dies can be very tax efficient for inheritance tax purposes. They skirt around the estate for inheritance tax, so the idea is that you set up a trust that effectively has nothing in it during your lifetime. You then write to the life insurance or pension provider informing them that when you die you would want any money under those policies to be paid into that trust that you've set up. When that payment is made, it then doesn't go through the estate, so it doesn't go down through the will. It actually, as I say, skirts outside the estate for inheritance tax purposes to ensure that it then passes into the trust. And that is really tax efficient and is a very good way of inheritance tax planning, and really should be something that anybody who has done a life insurance policy or pension policy should be considering. What is important though to think about in that situation is whether in that trust you actually would want to leave the money to your spouse. And the reason I say that is if you've gone to the effort of setting up one of these trusts and you've left it to skirt around your estate for inheritance tax, there seems little point in those trustees then paying that money out to your spouse, only for them to then die with the money in their hands, and then they pay 40% inheritance tax on it on their death. So what I would normally suggest in that situation is that you have a discretionary trust, the spouse of whom is one of the beneficiaries, and that the children or grandchildren or anyone else who you may wish to benefit are the other potential beneficiaries, and that money is only actually paid to the spouse as and when they need it, so that they're not paid a large lump sum of money which effectively then sits in their bank account that they still have when they die and 40% tax is paid on it. It is very simple to use to set up this kind of trust. As I say, effectively you're setting up an empty trust or a pilot trust you may hear people talking about. You need to check with the life insurance provider and the pension provider to determine whether they require the policies to be assigned into that trust or whether they simply need a letter of wishes stating that your client would want this money to be paid into this trust when they die. So, in conclusion, trusts can be used for a variety of reasons. They can be tax efficient or simply affect complicated situations that need to be formalised. The reasons that you may set up trusts, as I say, quite often are because they are tax efficient. The way I always try and get people to think about trusts is just that they are really like a bank account. People do shy away from trusts because they start to get concerned about trustees and what that means. It is a legal entity, a trust, so if you try to explain to people that it's like putting it somewhere else, they're simply a legal vehicle, really. The only thing I would say, though, that it is very important that you trust your trustees, because, of course, you are giving them full power to deal with any money in that trust. And that's really all there was to say. I'm just wondering whether anyone has any questions at all. Just find out if anyone's posted any questions. Can't see that there are any at the moment. If anyone did have any questions in the next couple of minutes, they wanted to type them in, you know, I'm here to answer them. If you do want to discuss trusts any further, that really is a snapshot of just a few trusts that you could do, and a few, I suppose, a few common themes in terms of when you may come across trusts. But there are other different types of trusts that people may wish to discuss with you, and so if you did want either to discuss with me or to put them in touch with me, that's absolutely fine. My contact details are there on the screen for you. The only other thing then to say is thank you very much for attending the webinar. Hope you found it useful. If you wouldn't mind just taking a few moments to complete our feedback survey and then submitting that to us, just so that we can learn on the experience of webinars, that would be brilliant.